Hear ye, hear ye, hear ye. All persons have any business before the Honorable Beverly Kenobi, Justice of the Norfolk Superior Court before the County of Norfolk. Draw near, give your attendance, you shall be heard. I'll take the Commonwealth of Massachusetts. Court is now open. You may be seated.
May I?
Please.
You're despicable.
So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ACCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and
I guess we know who this video is about, right? It's me, GONZO, fun size GONZO. So, Hanky Panky, he's been rubbing a lot of people the wrong way, right? When I watch him, I was like, oh, dang, dude. Sneaky snake, right? So this video is going to be from the first motions, I believe. I don't know. There's so much stuff coming out. I don't even know. Okay. But what I've done is I've taken the defense's first argument just to make their point, and then Hanky Panky in all his glory and all his wordplays solo. All right. So let's give it a gander. Welcome. Well, can I say that? Well, I'll just say welcome. Welcome.
Please the court. The proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony.
May I?
please.
Attorney Lessie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his intern. What is it? E or Z just trying to kind of figure out what is he wants to say, you know, as he's standing up there. It's almost like he's struggling to figure out what to say next. He's flipping through those pages like it's going to jump out on him. Hanky Panky is at a loss for words. Internships. As a neurosurgeon, he engages in
an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients.
Okay. Tens of thousands of patients in 30 years. 5 patients a day, 25. Carry the one. You know who could figure this out real quick? Trooper Paul. He's so good at math. Where is he when you need him? But anyway, in your comments, you guys will figure it out, I'm sure. Let me know if it's possible for tens of thousands of patients in 30 years. Okay, let's continue on. Oh, wrong button.
With head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's a principal investigator in THAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD in severe head injury, improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. His book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries. Intracranial pressure, number 2 on his journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16. Fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles. His presentations, specifically on fractures, basal type injuries, number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries. Over 100 lectures listed for reference, actually over 130.
Okay. So on paper, he looks good, right? Hanky Panky is just flipping through pages. And I think probably half of those pages don't even relate to Dr. Wolf. He's just making it look, you know, it's all about the optics, what it's going to look like. And Bev's just watching him flip those pages, right? Flipping those pages. I don't like it. Let's go.
And a number of web publications. So this neurosurgeon who has this extraordinary experience is qualified.
Exactly.
The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf treats patients that are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab, he's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear.
Hi there, students. Have you ever heard the phrase, as clear as mud? Okay, if something is as clear as mud, it's very difficult to understand.
That the injury that was occurred by Mr. O'Keefe was an injury known as counter-coup. And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards.
Okay. So here's a visual aid, right? The impact in this image is to the back of the head. All right. So what Hanky Panky is saying is that the impact occurred, the brain moves forward, and then you get the trauma to the front of the brain. So he says you could only get it when you fall back. Okay, that's fine. Because he probably did fall backward. Or he could have been hit, like a lot of us think, to the back of the head with something blunt. I think it was a weight in the basement because they had a bench with weights and whatnot. So that's right. Impact to the back of the head moves toward the front. And he's describing the exact same injuries that the coroner, I believe, described as well. Right?
On the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head.
What do you mean there's not enough force with a bat? Does he know what he's talking about? If he's claiming that Karen Reed hit him going 25 miles an hour backwards and it only hit his arm, that was enough for him to fall back, hit himself on the back of the head on the rock hard front yard to have him cause this type of injury. It's a stretch. It's a stretch, my guy.
Hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it.
Whoa.
But this expert does have that expertise. And it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. LaPosada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony.
Okay. He says he doesn't propose himself as a detective. Well, I beg to differ, because if you're trying to figure out cause of death, that's exactly what you're doing. You're investigating. You're trying to figure it out. So if he can't do that, then he's not qualified.
He is intimately familiar with counter-coup, having treated tens of thousands of patients, and he understands in counter-coup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of counter-coup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth. But we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Leslie, anything final?
Yes, thank you, Ron. Thank you, Mr. Brennan. Thank you.
He's such a nice guy.
Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Dalbert factors.
True.
And that is the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Dalbert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. One paragraph that doesn't address common acceptance, methodology, Dalbert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. Thank you.
Exactly.
Do you want to respond at all, Mr. Brennan?
At some point, arguments become semantical and theoretical, but not practical. This doctor has...
Man, he likes to use big words. I'm gonna have to break out old Webster's. What was that? Webster's dictionary. Let's go.
treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon, engaging in the operations in the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them.
A person who suffers 2 sharp, powerful blows to the head within a short period of time can suffer brain damage or even die. This, according to a new study in the medical journal Duh. Dr. Jack Kevorkian was responsible for another death this week, this time a 58-year-old woman. She is the 26th of Kevorkian's patients to die since 1990. When are people going to realize he is not a good doctor?
That's a little spoof on Dr. Wolf. Oh my gosh, Steve's gonna kill me. But anyway, I don't know, man. It's like, unless he said it, it doesn't fit the criteria. If it doesn't fit, it doesn't go in.
So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alisi, but that is so unnecessary because it's obvious. Thank you.
Okay. Thank you. All right, so we have a series of motions in limine. I'm going to start with defendant's motion
to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the
course
defense
there
on
is.
this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It
We
looks like,
We attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
did she adopt it? Was there, okay.
She did indicate, and that's part of my argument, Your Honor, which
So I'll go ahead, I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall.
So let me just have, so you're just trying to use it as a chalk, not an exhibit?
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity, or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's a very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
It would be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do an exhibit.
Okay, so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will call this. This deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people.
Okay, that's important. Different times by different people. You would want to know that. And you'd want the jury to know that. Right? I don't know why Bev is having such a hard time. Right? Hey, Mr. Brennan, is that okay with you? You do have an objection, right? I don't. If Karen Reed is supposed to have a fair trial, then make it fair, right? Like at the very beginning, it felt like she was yelling at the defense. You guys haven't been truthful. But Hanky Panky, who was a defense attorney, or still is, he knows the game, so he knows what to say to counter it. Let's roll.
All right. What's the objection, Mr. Brennan?
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there. But also, it doesn't give the full.
Okay. If it's a report, it can be used as evidence, right? And you could do whatever you want. At least this old cop head is thinking. If this report is not simple enough for the jury to understand, you break it down. If it's a chalk or an exhibit, why not? I don't get it.
Full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case, and I say that because we learned last night for the first time on a public airing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face.
Okay. When I saw this, I didn't understand what he's talking about. And if it just happened, was it in some media that she did? That she said he may have taken my vodka glass? I don't know. And he's spinning it to where he is saying that John O'Keefe took my glass. So message me down below and get me straight.
Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
Okay. All right, so, Mr. Jackson, what I'm going to do is just hold off. Hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. It's just, I need to hear more of the evidence again.
I understand.
And I'm going to read the transcript, so that will help me with
I think
this.
it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think that if the court would keep an open mind,
Sure.
if Ms. Hanley testifies, then that would be the appropriate sign.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
You're exactly right. It's not about hanky-panky's understanding. It's so the jury can understand it. Oof.
The defendant.
So I just want.
I didn't mean to interrupt, Mr. Brennan. Do you want to?
So I just want to know if that is part of the Aruba one.
Okay.
So our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then we may proceed with it. But in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay. There we go. All right. All right. So, Mr. Brennan, you can have a seat again, and we'll go through.
Your Honor, the defense is requesting that it exercise its broad disciplinary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view.
Okay.
So the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay. What are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions, and I think it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposal. So I need more information from both. So, Mr. Brennan, I'd like you to come up with a proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place, if that's what we decide. We may have to do it all at once.
Did you see that? Or did you read that? I put that so you can read it. She's saying we, when we decide, or what we decide. Is it we? Why would she use we? Why don't you say what you decide, then bring it to me? Both of you bring your ideas to me, and I'll decide. But she was saying we. And, well, I'll play it.
I do think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Exactly. You have to have the scene, right? If it's not the exact time, that's fine. We can imagine what it's like at, 2 o'clock in the morning with a little bit of storming. You guys live there. Those witnesses lived it, so they can imagine it. So you need to have the car at 34 at the exact area of where Karen Reed's Lexus was saw at, right? The location. They get pretty real close. So you have to have that as a witness. I would like to see it, right? She backs up, hits John O'Keefe on the arm. He spins, pirouettes, falls down, cracks his skull, and he dies there. They need to see that. Just like Miss Little said, to get the perspective.
Okay. All right, so let's try and figure out some of the particulars. 576, so Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested.
But it's not a given, okay? All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited back.
I don't care if it's a tradition. If you're the judge and you think it could impact something, wouldn't you want to deny it? Say no, they can go to a green room and watch TV from there, right? It's not complicated.
On their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that some anonymous person was uncomfortable. It seems as though the presentation has a deliberate point to promote a cause, but doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members. who are potential witnesses for the government. And certainly, I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in a courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses.
Stand by. You're not comparing apples to apples. It's apples to oranges, right? Higgins, cop. Alberts, cops. So if you're a witness, right, and you get put on the stand and you happen to be a cop, you got cop friends, right? And if you're a juror or whatever the case may be, you could be a little bit intimidated of future repercussions, right? I wouldn't put it past them, but you're not comparing Karen Reed's family, immediate family, to Higgins and Albert and all that, all those yahoos.
As should Mr. O'Keefe's immediate family.
Immediate.
The idea that witnesses should not come in after a
Immediate.
evidence rest and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may.
He's trying to play Mr. Nice Guy. I believe Karen needs to have her immediate family for support. Bite me.
Or even if they do become witnesses.
So 566, defendant's motion for panel voir dire. Who's arguing that? Okay, so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to...
Okay, well, we covered all...
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument, in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so
Yeah,
I think
'cause
the
you've done it.
questionnaire is more structured. It allows for all the different subject areas that are important to both sides.
Now listen, correct me if I'm wrong, but he was or is a defense attorney, right? So he knows what Jackson is trying to do because he's done it. And that's why he's saying, no, we're not going to do that because it gives them advantage. Of course, right? That's why you have a debate and you argue over what classifications of questions you're going to have, right? Let's go.
And may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or follow-up that's reasonable and necessary, and I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that, I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow, so I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it, and if you can't, I need that. You know, I need that by the end of today, if you're not going to agree to it. Have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we've got a backbone to start with.
So let's do that. What Mr. Brennan's new to the case, what I need in a questionnaire is it has to be one page, both sides. No more than one page. At the end of our hearing tomorrow, I'd like to talk about the particulars of it. We have a huge amount of jurors coming in.
Yeah.
And I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. 570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses. All right?
Thank you, Your Honor.
All right. Let's go, Action Jackson.
The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control.
To evidence about harassment and abuse of witnesses, I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me. Is beyond
That's funny.
It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door?
You see why people don't like this guy? He's pompous ass. Do you see? You've heard. Do you see? You've heard. Right? Like he's trying to sell her. You son of a biscuit.
We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to.
Wow.
The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses who harassed at the family events. That didn't happen.
Look at Jackson. He is writing his argument. That thing is smoking. His pen is smoking.
And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations.
Ooh.
That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note, okay?
Of course.
All right, go ahead, Mr. Jackson.
I just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening?
Do I make myself clear?
I'm sorry, I wasn't listening.
Ow! Right? I feel like throwing a coffee cup. Let's go. Wow. It's going to get dirty. It's going to get real dirty. Wow.
I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aiden Kearney.
Turtle Boy.
And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said. At the lowest burden known in criminal justice.
Dirty.
So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed.
So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. Arguing it for the defense.
Your Honor, I am. And to answer your question, the defense preference would be for the Commonwealth to go first, and we would respond, including with regard to the motion.
Okay. So, Mr. Brennan, our paper 386, your number 12.
Your Honor, our paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol.
This was something that you guys agreed to with this hospital.
Wubbles objects, citing the hospital's policy that blood can't be taken without consent from the patient, a warrant, or a patient that is under arrest. That's when Detective Payne reacts.
We're done. No, we're done. You're under arrest. Hey, we're done, sir. I have administrative.
Payne says she was interfering with the investigation and that his commanding officer told him to make an arrest.
Okay, so this happened in Utah, I believe. So it begs the question, did the prosecution obtain Karen Reed's blood by consent, search warrant, or did they just take it? You guys probably know.
We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth vs. Callanan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right.
I'm not going to take his word for it, though.
Alessi.
Thank you, Your Honor. Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts as well as impliedly by Ms. Knowles that they're not reliable, and here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings.
I don't get it. If it's in the hospital's policy that cannot be used in a court setting, why are they even using it? Can somebody explain that to me? If that's true, which I believe it is, it should not be used.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there is a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
okay.
Martin Weinberg. If, in fact, the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches.
Yeah.
And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached, and the entire case would go away.
All right, thank you very much.
Of course.
Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan?
Thank you.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works, so why don't you tell us?
Neither do I.
So, as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th.
Monday.
As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown, and the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which won't.
So he's telling Bev, pump the brakes, slow it down, because things could change. Wow. This is getting interesting. Let's go.
At the same time, the Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule, that would be helpful information to inform this as well.
All right, I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40, how many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury empanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
Well, oh, wrong one. This one? No. This one. There we go. Well, that was it. Old hanky pink on full display. He's sneaky, for sure. He knows the game. He walked that side as well. So he's going to throw as many curveballs as he can. And Bebs is helping him. So it sounds like it's going to get continued. If the First Circuit drops those 2 charges and the jury is sworn in, it's got to throw it out. I don't think Bev's going to swear the jury in until the First Circuit is done. Right? But anyway, that's the show. Like, subscribe, share. Sharon is Karen. But anyway, I think we got a lot of work to do next week. I'm going to be behind again, but hopefully Brian and I will get together on Saturday, next Saturday, and Steve-O. So anyway, thanks for watching. Stay safe and make a difference in somebody's life. Later.
One Sam 5 and 1 Sam 6, copy of 425 call.
Copy. 1 Sam 5 en route.
1 Sam 6, copy, en route.